All right, so this paper is sort of by way of a provocation and a work in progress, which means you can disagree with it violently, although not too violently, and also tell me what I'm doing wrong. So anyway, over the past couple of decades, the language of brands has become inextricably linked with the language of commerce. And a huge amount of commercial activity, particularly in the field of private equity, has been concerned with the disposal and acquisition of brands. And the value of acquired brands may now be shown on the balance sheet of a company. This wasn't true until the late 80s, even though there is no agreed process for actually valuing a brand, nor indeed, as I'll suggest later in this lecture, is there any agreed definition of a brand itself. So this lecture is by way of a progress report. A few years ago, I published a couple of articles on the relationship between trademarks and brands, and a major theme of these articles was to try to identify the difference between trademarks and brands, especially since the two terms are commonly used interchangeably, not least by the judiciary itself. I then went on to map out in these articles the extent to which the legal protection afforded to trademarks and to brands did or did not overlap. I took the view at the time that prevailing trademark law, as interpreted by the Court of Justice, primarily recognized trademarks as indicators of origin and not as embodying what might be termed wider brand values. And my reasoning at the time had been based, in large measure, on the European Court of Justice judgment in Arsenal and Reed, which had been handed down in 2002. And this is just a little chart to show you how incredibly valuable brands are. Okay, Arsenal and Reed. I'm probably all familiar with the case. And briefly, Arsenal had sued Matthew Reed for trademark infringement, and Reed had been selling clothing outside the club stadium, carrying trademarks, which had been registered by Arsenal, among other things, for clothing. One question put to the Court of Justice was whether, in interpreting Article 5.1a of the Trade Mark Directive, that is, the use of an identical sign on identical goods, use might be infringing even if the sign was not being used as a badge of origin, but rather, in this case, as a badge of allegiance. Now, in his opinion, Advocate General Colomer had argued that to understand trademarks simply as indicators of origin was, he said, simple reductionism. They might also indicate quality, the reputation or the renown of the product, or they might be used for advertising purposes. However, the Court of Justice took a more cautious approach, and some might say a more balanced approach. I think I said that at the time. It held that non-trademark use could be infringing, but only if it affected or was liable to affect the functions of a trademark, and in particular, the essential function of guaranteeing origin. And I concluded from Arsenal and Reed that while the Court of Justice did not rule out that a trademark might embody brand values, nonetheless, its key role continued to be as a badge of origin. Now, I was minded to revisit the issue of trademark protection versus brand protection after reading the recent Court of Justice decision in Interflora and Marks & Spencer. In this case, too, a very key question was what constituted infringing use of a sign under Article 5.1a of the directive. However, by contrast to the decision in Arsenal and Reed, the Court of Justice held that Article 5.1a might come into play if any of the functions of a trademark are adversely affected, with no particular emphasis placed on the role of trademarks as a badge of origin. It also identified these other functions. According to the court, a trademark might be, quote, in addition to an indication of the origin of the goods or services, an instrument of commercial strategy used inter alia for advertising purposes or to acquire a reputation in order to develop consumer loyalty. Now, it seems to me that the Court of Justice has moved a considerable distance from the cautious approach it took to protecting brand values in Arsenal and Reed. So on the 10th anniversary of that case, I thought it might be interesting to once again ask where the relationship between trademark protection and brand values now stands under the directive. To that end, I'll first briefly outline how I would define the differences between trademarks and brands. I'll then go on to look at those areas of trademark law where the courts have been concerned with the protection of what I'm going to call brand values, and I will suggest there are three key areas. The first, Article 5.2 of the directive, which, as you know, covers trademarks with a reputation. The second and the primary focus of this talk would be Article 5.1a of the directive, which is concerned with double identity cases. And the third, Article 7, which concerns exhaustion of trademark rights. And I'll finish by where I think the law should go in this area and asking whether the legacy of Arsenal has been a particularly benign one. So let's look at the difference between a trademark and a brand. Sorry, that's what I'm going to do. Definition of a trademark, I think we all know that's taken from the directive, so I won't repeat that. Definition of a brand. Well, one that I've found, which comes from a fairly influential source, is from the International Trademark Association, where it says a brand is a trademark or combination of trademarks that through promotion and use has acquired significance in distinguishing the source of origin of the goods or service. Brands are intellectual property and as such a part of the assets or goodwill of a company and may be bought and sold like any other asset or property. Now I would take issue with this final statement. For those involved with brand development, the definition of a brand would be far broader than that offered by Inter and would not fit neatly, I don't think, into any obvious categories of intellectual property. According to one observer, quote, a useful way to conceptualize a brand is an aggregation of assets, which includes, but what is not limited to, the trademark. These assets might include a visual identity or identifying trade dress or a particular marketing or advertising strategy. Alternatively, brands have been identified as a combination of legal rights, together with, quote, the culture, people, and programs of an organization within which the specific logo and associated visual elements, plus a larger bundle of visual and marketing strategy intangibles and the associated goodwill are also deployed, so lots beyond what we might think of being covered by trademark protection. Perhaps the one common attribute that I think is given to any successful brand is its ability to extend beyond the product with which it is associated. This one key feature of a brand, which is generally known as transferability, is, in other words, it serves, quote, to transfer consumer loyalty between products, services, and categories over time, and to separate it from tangible production. And this seems to me a perfect example of a transferable brand, Virgin, which, as you see, covers like a vast number of different enterprises, and we also know it's now taken over a bank, but all identified by the Virgin brand. Well, let us now perhaps turn to a couple of real-life examples of a brand, just to illustrate what I'm saying. So Coca-Cola used to be the world's most valuable brand until it was knocked off its perch by Apple. According to Coca-Cola's CEO, its premier position came from its, quote, relentless focus on building customer connections, its strong storytelling, its iconic contour bottle, its unparalleled global scale, and its winning advertising. And one bit of its winning advertising and a kind of urban myth which has grown around Coca-Cola is that somehow Coca-Cola invented Santa Claus. But they certainly associated their brand with Santa Claus. And I could go on about that, but I won't at this point. But what of Apple itself? Well, one observer notes about Apple uses the Apple brand to compete across several markets, including computing, smartphones, and digital music, and recently books and magazine publishing, so transferability. But apart from its transferability, quote, the Apple brand personality is about lifestyle, imagination, liberty regained, innovation, passion, hopes, dreams, and aspirations, and power to the people through technology. I haven't finished. The Apple brand personality is also about simplicity and the removal of complexity from people's lives, people-driven product design, and about being a really humanistic company with a heartfelt connection with customers. So not much. But we're all probably aware that Coca-Cola owns a trademark for the shape of its iconic bottle and for its name, and that Apple is a registered trademark across a range of goods because each of these, the bottle, the apple, acts as a badge of origin, and the name Coca-Cola, and indeed the name Apple. But what I sought to suggest here is that the Apple and Coca-Cola brands, and indeed brands in general, go far beyond any simple role as an indicator of origin. Indeed, however they are defined, some brands are understood to embody both significant cultural and economic capital, as well as simply being a badge of origin, and Apple, I would suggest, is a perfect example. And what I like about these two illustrations is how Apple built its brand. So you have the young Steve Jobs holding an apple, and by the time we get to the last frame, we see the apple, the iconic Apple logo, but also Steve Jobs. I mean, was he protected by a trademark? No, but yet, seriously, he was a really important part of the Apple brand, I would suggest. So brands, trademarks, not the same. Now, there's certainly no doubt that the wording of the Trade Mark Directive explicitly recognised that a trademark might have other functions which go beyond its role as an indicator of or badge of origin. Thus, recital 11 of the Trade Mark Directive opens with the words that the protection afforded by the registered trademark, the function of which in particular to guarantee the trademark as an indication of origin, has been generally understood, including by the Court of Justice in Arsenal and Reed, to mean that it will have other functions, and as well. I mean, that's why they said that the trademark use might affect other functions. Use of a sign identical to a trademark might affect other functions, or functions in the plural. However, I think it would be fair to say that in the early days of the directive, most observers believe that these other functions, which to be recognised and protected, would be under Article 5.2 of the directive, which protected trademarks with a reputation against dilution and unfair advantage. That is Article 5.2. In fact, that was not the case. And I would suggest, in fact, that the earliest cases to recognise that trademarks might embody what we might term were brand values were not concerned directly with infringement at all, but with exhaustion of rights. And I think that's quite interesting because that's scarcely ever noted, and I think is actually in its own way significant. So let's look first then at exhaustion of rights and brand values. So as I said, I think it's too often overlooked that the first case is to identify and protect what we might term brand values embodied in a trademark were those concerned with exhaustion of rights under Article 7.2. Now, Article 7.2 allows the proprietor to prohibit the use of his mark on goods which have already been put on the market in the EU if there are legitimate reasons for him to do so. And as early as 1996, and without reference to Recital 11 at all, in Bristol Myers Squibb and Paranova, the Court of Justice held that a legitimate reason to prohibit resale of goods under a registered trademark might be if the repackaging of such goods were to damage the trademark's reputation. 2 years later, in Parfum Christian Dior, SA, in 1998, the Court of Justice said that it was possible to prevent further commercialization of goods if such commercialization affected their, quote, mental condition. That was the words that they used. In the Dior case, for example, which, as the court noted, concerned prestigious luxury goods, it held that the reseller must not act unfairly in relation to the legitimate interests of the trademark owner. He must therefore endeavour to prevent his advertising from affecting the value of the trademark by detracting from the allure and the prestigious image of the goods in question and from their aura of luxury. So interestingly, apart from some discomfort expressed by the English judiciary immediately following Dior, for example, by Mr. Justice Laddie in the Zeno Davidoff case, there's been little controversy over the fact that Article 7.2 of the directive seems to protect trademark functions which go far beyond identifying origin. And this is all the more surprising given that for a trademark to get protection under Article 7.2, the mark in question does not even need to be a mark with a reputation, as it does under Article 5.2. It needs simply be a mark whose reputation is at risk, which is quite another kettle of fish, I think. Furthermore, the protection for the mark's mental image has expanded since Dior. And I mean, it was raised in L'Oreal and eBay in 2011, but I think one of the interesting cases was Porter Cabin Limited and Prima Cabin, also in 2011. And here the Court of Justice looked at the application of Article 7 to goods which are resold on the internet, and in this case it was the resale of used mobile buildings or portable toilets to you and me. I mean, they call them, that's what Porter Cabin basically mostly does. And they looked at it by this resale by reference to keywords. The Court of Justice held that the proprietor of the earlier mark is entitled to prohibit advertising by use of a keyword on the internet if, among other things, the manner in which the relevant goods are advertised, or in light of their volume, their presentation, or their poor quality, risks seriously damaging the image which the proprietor had succeeded in creating for his mark. If any of those things were true, then that resale could be prohibited under Article 7.2. And I would suggest that while here the court is very much recognizing the value that such marks might have as brands rather than trademarks, I mean, it seems to me to go far beyond protecting the mark's role as an indicator of origin, it is also left behind the world of luxury, allure, and prestige, as was the case in Dior, simply to protect image as such. So that seems to be a very important line of cases which look at brand values and seek to protect them, but which is not really readily acknowledged to do so. Now, I've also suggested that despite expectations that interpretation of 5.2 of the directive would have the most immediate relevance to protecting brand values, that was not to be the case either. And in fact, it was under those cases concerned with a double identity infringement, Article 5.1a, most notably Arsenal and Reed, that the court first began to recognize trademark functions in the broader brand sense, and over the past decade to draw the parameters of what was meant by that. So cases concerning Article 5.1a. Now these functions, these other functions, were left vague in Arsenal. The court simply referred to functions in the plural. 2 years later, in Opel and Alltech in 2007, the court confirmed that Article 5.1a applied to cases in which a third party's use of a trademark or use of a sign affected or was liable to affect the functions of the registered trademark beyond its role as a badge of origin. But again, as in Arsenal, the court did not elucidate what these additional functions were, which seems to me a pretty important thing if you're going to talk about functions in the plural. And in fact, as we know, in the years following Opel and Alltech, the question of the protection of the non-origin functions of the trademark did move to cases which involved Article 5.2. So in Intel, we got the Court of Justice first ruling definitively on what constituted dilution of a mark. And then in L'Oréal Bellure, we got the court looking at what constituted unfair advantage when a third party seeks to ride on the coattails of a mark with a reputation. And in those cases, it looked very, clearly they were going beyond protecting the mark as a badge of origin. Not surprising, really, that's where people expected such protection to arise. Now, as we know, following L'Oréal, the definition of what constitutes unfair advantage provoked considerable controversy. Lots of people wrote lots of articles about that. However, what was less remarked, and seems to me equally important, was that in L'Oréal and Bellure, the Court of Justice was also asked to look at trademark use and Article 5.1a. And this was in the context of the defendant's use of the L'Oréal marks in comparative advertising. And in doing so, the Court of Justice held that a sign might infringe under Article 5.1a, even if its use did not affect the essential function of the mark as a badge of origin, so long as that use was liable to affect some other function of the mark. And it then went on, for the first time, it seems to me, to give a non-exhaustive list of what those other functions might be. So they could guarantee the quality of the goods and services, communication, investment, and advertising. So suddenly the court is telling us what those other functions which might be protected would be. So I think there are two significant aspects to this part of the L'Oréal judgment. First, even though the court cited Arsenal and Opel as precedent, as I said, it seems to me the very first time that it actually precisely identified what additional functions of the trademark might be, although this was not it wasn't that there was more. They didn't say these were the only functions it could have. Secondly, the court made the specific point that under Article 5.1a, and this seems to me equally important, a trademark might be infringed even if its origin function is unaffected. So it's not like, it has to affect its origin function and it might affect these other functions as well. It could be if any of these functions of the trademark was unaffected. And this was the case, again, even if the mark in question is not a mark with a reputation, which was the criterion for finding infringement under Article 5.2. Now, ironically, although I've suggested that attention after L'Oréal primarily focused on the Article 5.2 aspects of the case, it's the aspects of the judgment which refers specifically to trademark use had immediate and considerable influence. And this is because the question of what constitutes trademark use has been central to a line of important cases which have concerned internet advertising and which came before the court shortly after L'Oréal. In Google, as I'm sure, do you all know the Google case? If you don't, quickly, the issue concerned the liability for trademark infringement of an internet referencing service provider, namely Google, which stores as a key word a sign identical with a trademark and organizes the display of advertisement on the basis of that key word. Google also addressed, though, the question of whether the advertisers, the use which advertisers made of that key word might make them liable for trademark infringement. So it also looked at the use by the advertisers as well as the use by Google. Now, in the case, Google was found not to have any liability, that it was not using the keyword that was not trademark use in the course of trade, which could constitute infringing use. However, in certain circumstances, the court did hold that the advertisers might be liable, and in identifying these services, the court further elucidated what it held to be the functions of a trademark. And it said, noted that there would be infringement under Article 5.1a if the use by advertisers were to affect the function of indicating origin or one of the other functions of the registered mark. And it then went on that in the present context, the relevant functions that were at risk by the use of the keyword were those of origin and advertising. In the case of the origin function, the court in Google held that where an ad does not enable an average internet user, or enables that user only with difficulty, to ascertain whether the goods and services referred to therein originate from the proprietor of the trademark or a undertaking economically connected to it, or, on the contrary, originate from a third party, then the origin function is affected. So if the average consumer can't tell where the goods come from, that means that the origin aspect is affected, function is affected. In relation to the advertising function of a mark, the court noted that since the course of trade provides a varied offer of goods and services, the proprietor of a trademark may have not only the objective of indicating by means of that mark the origin of the goods and services, but also that of using its mark for advertising purposes designed to inform and persuade customers. So it's saying, that marks will have both an origin function and an advertising function. And if the average internet consumer was unsure as to whether there was a link between the registered trademark and the advertiser, then the conclusion must be that there is an adverse effect on the advertising function of the mark. So that, in a nutshell, is what they were saying. Now, it seems to me that as far as the application of Article 5.1a goes, the reasoning in L'Oreal, and particularly in Google, seems to be problematic in a number of important respects. For one thing, the Google judgment seems to have introduced the need for confusion into double identity infringement cases by the back door. You have to ask, don't you, whether the average internet consumer is actually confused in order to ascertain whether the advertising or origin function of the mark is going to be affected by the use that is made of the trademark. And that, therefore, and that directly goes against what was said in Google when the court said that where the marks and goods are similar, they're not identical under Article 5.1b, there is less protection given to a trademark than under Article 5.1a. I don't think that seems to be the case anymore. Secondly, once again, Google appeared to confirm that the reputation and more widely defined perhaps brand values of a trademark would be protected even if it was not a trademark with a reputation, as has been defined in relation to Article 5.2. And thirdly, it was held in Google that there could be infringement under Article 5.1a, and this is equally as important, even if the essential function of the trademark as an indicator of origin remained unaffected. So it doesn't even have to affect the origin function of the trademark anymore. Now, a number of further cases on trademark use followed, including actually L'Oreal and eBay, which I haven't got here, as well as Portakabin and I won't even try to pronounce that, but that's another case which looked at this issue. But it seems to be Interflora and Marks and Spencer that the court addressed non-origin functions of a trademark and their relationship to the double identity rule in most detail. And so I want to now go on to an examination of Interflora and suggest why, in my opinion, it did not do so successfully. It was unsuccessful in the way it addressed this relationship, and why, therefore, the extent to which trademark law should and will protect brand values remains contentious. Okay, so Interflora is a network of florists with whom customers may place orders for delivery of flowers. Now, orders placed on its websites are filled by the network member closest to the address where the flowers are to be delivered. And Interflora is also the proprietor of a registered community and United Kingdom trademark for the word Interflora. And now, both parties accepted that Interflora did indeed have a reputation in the EU and the United Kingdom. Marks and Spencer's, which we know is an equally, well, in the UK at least, well-known brand, if you like, purchased the keyword Interflora, as well as variants on the word and expressions containing the word Interflora as a key, as a ad word under from Google. So internet users who Googled the word Interflora, or one of those variants or expressions, would receive, among their sponsored links, which comes up on the side of the screen, an M&S advertisement for flower delivery. So Interflora sued for trademark infringement in the High Court. Among the questions addressed by Mr. Justice Arnold to the Court of Justice was whether, under Article 51A, the proprietor of a trademark is entitled to prevent a competitor from displaying, on the basis of a keyword which is identical to that trademark and which has been selected in an internet referencing service by the competitor without the proprietor's consent, an advertisement for goods and services identical for those for which the mark is registered. So are you allowed to purchase a keyword and then display it, use it to display your own advertisement? And whether in those circumstances it is relevant that the advertisement concerned is liable to lead some members of the relevant public to believe incorrectly that the advertiser is a member of the trademark proprietor's commercial network. So in the Interflora case, people might think, oh, Marks & Spencer's is one of the companies that will deliver Interflora flowers. And that was the basic question. The European Commission intervened here, interestingly, and they asked the court for clarification on precisely those points that I have highlighted in relation to Google. So the European Commission argued that Article 51A should protect only the mark's origin function, while those other functions, which I've suggested map onto wider brand values, should be protected, if at all, by Article 5.2, not least, they said, the EC said, because that provision was directed not at all registered trademarks, but only the marks with a reputation. So precisely the issues that I've been raising here. Well, the Court of Justice disagreed. It held that the directive did indeed give absolute protection to a registered trademark in double identity infringement cases. However, it went on to say that absolute is not entirely absolute. In fact, Article 51A is only intended to ensure that a trademark can fulfill its functions, with an S, and will take effect only when any of those functions is liable to be adversely affected. As to those functions themselves, according to the court, a trademark is often an instrument of commercial strategy used for advertising purposes or to acquire a reputation in order to develop consumer loyalty, as well as being a badge of origin. Thus, it was in L'Oreal, as we've seen, it was the investment function of the mark that was potentially at risk. And in Google, it was the advertising function as well as the origin function. The court then went on to give guidelines as to when and how each of these functions, the origin function, the advertising function, and the investment function, might be placed at risk. In relation to the origin function and the advertising function, it reiterated the Google definitions which we've already considered, and we looked at those in relation to Google. Turning to the investment function, which had not been examined in either L'Oreal or Google, in fact, just kind of mentioned in passing, oh, this is something else a trademark might protect, the court identified this function by saying a trademark may also be used by its proprietor to acquire or preserve a reputation capable of attracting consumers and retaining their loyalty. It went on to say that although the investment function of a trademark, quote, may overlap with the advertising function, it is nonetheless distinct from the latter. Indeed, when the trademark is used to acquire or preserve a reputation, not only advertising is employed, but also various commercial techniques. Well, as soon as you say that, you think of Steve Jobs standing in front of a giant iPad or something. So where that fits with trademarks, I don't know. It concluded that where a third party dealing in identical goods with an identical sign interferes with the proprietor's use of its trademark to acquire and preserve a reputation capable of attracting consumers and retaining their loyalty, the proprietor is entitled to prevent such use under Article 5.1a. It also confirmed, in case there was any doubt, that there are no grounds for holding that only trademarks with a reputation are capable of having functions other than those of indicating origin. So all marks deserve this kind of reputation. Now, I began this lecture by saying that I believed in Arsenal and Reed the court had taken a cautious approach to expanding the protection offered to trademarks beyond their role as a badge of origin. But I think it did crack open a door to the protection of wider brand values. 10 years on, it seems to me, the decision in Interflora demonstrates that at some point, and that point is undoubtedly when it began to consider trademark use on the internet, the court threw open the door and rushed through. The description of the investment function of the mark given by the court in Interflora as using a mark to acquire and preserve a reputation by employing not only advertising but other techniques, as I said, seems to me to replicate the definition of a brand which I gave at the start of the lecture. Now, is this a bad thing? After all, as the court points out, trademarks are indeed the objects of considerable investment, and should not that investment be protected, whether or not it is intended to protect the mark's origin function or simply its general attractiveness? I mean, should we mind that these other functions of a trademark are now being recognized and protected in this way? And it seems to me that, okay, yes, it's right that the investment should be protected, but I do think not through the use of Article 5.1a. And that's because I think, as the law now stands, the use of Article 5.1a to protect functions beyond the origin function inhibits the proper working of a competitive market in the EU by being both overprotective and underprotective of the mark. And I think the way post-Interflora, the way Article 5.1a is interpreted, is overprotective because it appears to allow any trademark owner, whether or not his mark has acquired a reputation through investment and nurturing, to argue that it is threatened by the use of an identical sign on identical goods in a broad range of situations, such as use by a keyword or in comparative advertising. So it allows, so whereas Article 5.2 was meant to really be there for trademark owners who've really invested, perhaps, in turning their trademark into a brand, the way 5.1a is now being used would appear to give that protection to any trademark where one of its functions is threatened. But I'd also go on to say that the approach to Article 5.1a is underprotective. Well, why do I say that? Well, as you recall, Recital 11 stated that the protection afforded in double identity cases should be, quote, absolute. But the implications from Google and Interflora is that the claimant in such a situation may actually have to prove that there is a necessary link made in the minds of the average consumer, so that the functions of his trademark will be adversely affected by use of the latest sign. And this is not, as the court actually acknowledged in Interflora, absolute protection. So it's actually both undermining Article 5.1a and also making it spread to situations where I don't think it should. Well, what is to be done? As I noted in Interflora, the Court of Justice suggested that Article 5.1a should only come into play when the origin function... As I noted in Interflora, the European Commission suggested that Article 5.1a should only come into play when the origin function of the mark is under threat, not these other functions. But I say that that doesn't actually go far enough. Instead, I want to argue that, counterintuitively perhaps, that the best protection for an open competitive market is if the protection afforded by Article 5.1a is indeed totally and absolutely absolute. That is, in all double identity situations, infringement should simply be assumed by the court. Then it would be open to the defendant to offer a defence, for example, that its use was descriptive, or in the case of comparative advertising, referential. If the court is no longer obliged to judge whether such use affects the origin functions of a mark, a defence would be able to stand or fall on the simple question of whether indeed it was used as a trademark. Such an approach would provide more certainty for both parties, and it would strengthen the defences to trademark infringement, I think, available to third parties, say in the Arsenal case, for example. If Article 5.1a no longer entailed an examination of whether or not the non-origin function was at play or were being affected, then the fact that trademarks might have other functions which overlap with brand values could continue to be the rightful and solitary concern of Article 5.2. Indeed, it seems logical to assume that in its first incarnation, Article 5.2 was specifically directed at what is generally deemed to be the most valuable attribute of a brand, that is its transferability, because in its original form, Article 5.2 was directed at the use of a similar or identical mark or sign on dissimilar goods. So it seemed to be talking about transferability. The fact that the protection of Article 5.2 has now been extended to protect these same marks on similar goods seems to me to stray from the original intent of Article 5.2, but not necessarily to be a problem of overprotection, since given the emphasis placed on the distinctiveness of a trademark and in the global approach and on Sable and Puma, such marks would probably have be found to be infringed anyway. Now, interestingly, in L'Oreal and eBay, in the High Court, Mr. Justice Arnold suggested that there are apparently now 6 conditions to satisfying Article 5.1a. That is, first, there must have been the use of a sign by a third party. Second, that sign must have been in the course of trade. Third, such use must be without the consent of the trademark proprietor. Fourth, the allegedly infringing use involved the use of a sign which was identical to the trademark. Fifth, that the sign was used in relation to identical goods and services. And sixth, that use was affected or was liable to affect the functions of the trademark, and in particular of the trademark. His own suggestion was that once it was shown that the first 5 pertained to whatever was being alleged, then we could assume that the 6th was satisfied. If you could show the first 5, then you could assume that the origin function of the mark would be affected under Article 5.1a. But as we've seen, most notably from its decision in Interflora, the European Court was not going to be knocked off course by Mr. Justice Arnold's suggestion. Interestingly, too, in their recent study of the overall functioning of the European trademark system, the Max Planck Institute took a similar approach, suggesting that the double identity rule be reserved for cases where the sign is used for designating the commercial origin of goods and services which do not originate from the proprietor. But they also said that that in order to ensure this was the case would entail such a profound change to the current trademark regime that they would not even propose it. So they said, this is what it should be, but we're not even going to try and propose it. And I agree. It seems to me that the Court of Justice started out with something in Arsenal and Reed, and at this point it's difficult to see, following Interflora, how they can kind of backtrack and say, actually, that's not really what we meant, or we've gone off in the wrong direction for the last, 10 years? So I agree with, it seems very unlikely that things will change, but it also seems in a way that they've got themselves into a terrible pickle, which is difficult to see how they're going to find their way out of it. And then finally, Article 7, with the outrider that people sort of ignore. Well, again, it seems to me that there are anomalies under Article 7, the fact that there is no need for a mark to have a reputation for its mental image to be placed at risk. And indeed, you could say that the whole notion of a mental image is even more vague and uncertain than the notion of an investment function. But I would also go on to say that the thing about exhaustion of rights, before Lionel leaves, I have one more slide that he would like. I thought if we were going to have an Arsenal slide, we should have a Tottenham slide.
I'm repulsed. I'm going to have to be sick.
Anyway, but I also think that Article 7 will never be changed without some kind of political will, because it seems to me the whole exhaustion of rights area has to do with politics more than it has to do with trademarks. So that's where I'd like to finish and just say, 10 years on from Arsenal and Reed, the court's gone completely in the wrong direction. Should turn back, but probably can't at this point. Thanks.